Okay, folks, good afternoon. Thank you for coming. We also have some folks on Zoom that I cannot see, but my guess is a good number of John Marshall law students. Good to have you join the program. So Sean and I, here in Atlanta, we do a fair amount of police cases. We get a lot of calls about police cases, and the idea for this program really kind of grows out of our desire to see more lawyers do police cases and our desire to kind of streamline our own processes for how we screen and evaluate police cases. I guess the one thing that I want to say, sort of as a warning or as a cautionary note, although we're encouraging lawyers to think about doing police work, don't lie or fool yourself into thinking this is the kind of work for you if you're not really committed to doing it. I mean, police cases are not like auto wreck cases. I mean, it's not for everybody. It's not for the timid. I think it takes some courage and some fortitude if you're going to do these cases. And as a law firm, if you're going to do these cases, I think it takes adequate staffing and adequate funding. I think they take a commitment. But the one good thing about police cases now, unlike ever before in the 30 years I've been practicing, I think more and more police cases are viable. I think there's a greater need for lawyers who will do police cases. They're good cases on liability, good cases on damages. There are a lot of cases that we turn down just because we can't do but so many. So if you are someone as a lawyer that's thinking about a way to sort of, build a practice or sort of cut your teeth, so to speak, I think there's some great opportunities to do that in the context of police cases. And there's one example I will give. I will not name the lawyer, but one of the rewards, I think, of doing police cases is the exposure that you get. And there's some lawyers who I think have kind of, dabbled in this work a little bit for high-profile cases. They get on TV. They don't really have the heart or commitment, per se, to do these cases, but they get great exposure. And they get great results, and they parlay that into other stuff. I mean, hopefully you would go into it for other reasons, but the more the merrier, because there are lots of folks out there who are not even having a lawyer or a law firm look at their cases. The other sort of message I want to sort of convey to everybody, because for this program, we specifically invited not just lawyers, but also paralegals, investigators, and folks who do intakes. I believe that for most lawyers and for most law offices, the lawyers are only as good as the staff. And so if we're not getting good information about what happened, when it happened, how it happened, if we don't have good paralegals and good intakes and do good investigation, it's gonna affect our ability to sort of effectively evaluate and screen a case like that. John?
I'll just piggyback off of that. Particularly lawyers who are starting new practices or just law students that are on this Zoom. What Sam said is important. You as a lawyer can only go so far as your staff. And I've been fortunate and blessed that I came into a law firm that Mr. Sistrunk had set a standard, an environment to be conducive of having the best staff. And so, as Sam said, you can only go so far, but in civil rights cases, it is even more critical because, as they say, the devil's in the details in these cases, and you got to have certain facts and certain investigation aspects of those facts to make sure you get through some very, very difficult case law. I also piggyback on something else Sam said. Civil rights work is not something you just do because you want to make some money. There's a lot of things you can do in life to make money. And there's a lot of type of cases you can do as a lawyer that are more profitable than civil rights cases. So you do this because you have a passion and a desire to effectuate change. You know, we all start law school and say, I want to be a lawyer to change the world. And then you realize the world is very difficult to change. But one thing about a civil rights case is you actually can make a difference. Maybe not in the way that you thought you could as a young law student, but you can make a difference and change. And I've been fortunate enough in working for Mr. Cochran, working at the Cochran firm, doing cases with Sam. We haven't always got the results we wanted, but we have always been able to do something that I think significantly carried the ball to the next step. So if you're going to do it, but do it for the right reasons. Now, that being said, Sam is also right. You can actually make some money in this space. It's not crowded like trucking accidents or medical malpractice cases or premise cases. You don't have a bunch of lawyers out there on TV talking about, I got you a check because you got beat up by the police. So the space is small. The opportunity for a lawyer who wants to really invest the time, resources, and energy in doing it, there's something there for you. And there is a lot of very successful lawyers in this city who've done that and make a very, very good living and do very well in making a change in our community. So that's the other part. There's something there. And Sam is right. One thing about a civil rights case, because it typically involves a municipality, the news are always interested in what's going on with the area of law and order. You're going to get the opportunity to get in front of the media, to get media attention about your case for the benefit for your client, but also you're going to be known as a lawyer that wants to fight for your client, because civil rights cases is also about the community. So you're going to also be someone that's being seen as someone who fights for the community. Last thing I do before I give it back to Sam is what I want to make sure we get out of this thing is making sure if you are interested in doing civil rights cases and you have that passion, you have that desire, pick the right case. Know what you're looking for, because there's a lot of bad outcomes. There's a lot of bad actions by officers that are not viable claims. So there's some bad incidents and things that we say, you know what, that is clearly inappropriate, was wrong, but doesn't mean you got a good case. And what I also hope is that we can help in any way to shine a little light on what a viable civil rights case looks like, so that you don't have some of the troubles I had going out early. The lucky thing about me, though, is my early endeavors in civil rights was next to probably the most renowned civil rights lawyer in recent history, which was Johnny L. Cochran, Jr. My very first case was in Buckhead. A young man got shot and killed by a police officer. And Mr. Cochran took the lead, but let me realize and understand the importance of the legacy of our firm in handling these cases. So although he took the lead, he made sure I was right next to him. It scared the hell out of me, but it made me a better lawyer and made me a better understand how important these cases are. So with that, let's see if we can kind of...
Yeah, so we do have a PowerPoint that's kind of our only outline. We kind of allotted 90 minutes, but this is self-moderated, so that may come with some risk in terms of Sean and I moderating ourselves. But before we get to the PowerPoint part, what I want to do and have Sean do also is I want Sean to say a little bit more about how he got into doing police cases. And let me tell you sort of how I got into police cases. I was a public defender in Washington, D.C. for about 4 years. I had only been out of law school maybe 6 years. I came to Atlanta in 1999 to work with Ed Garland's office, who is a pretty well-known criminal defense lawyer. I had never done civil litigation before I came to Atlanta. And Ed, who's known for criminal defense work, had an interest in civil rights, was pretty fearless, was at least for that day and time and still today, a sort of a racial social justice type of lawyer. And so he threw me out there. I mean, he let me, and he made decisions on police cases that immediately just gave me the opportunity to start doing this work. I found an article here from 1999, like November of 1999. One of the first police cases I had was in Monroe, Georgia, where some police officers were hiding in the bushes, sort of doing surveillance on some young black men who were literally kind of folks living on the other side of the tracks in Monroe. And they had a Boy Scout with them who they were doing ride-alongs. And so they had this Boy Scout with them, and they were hiding in the bushes watching this house where these young black men were out front. And the kids, they saw them, or at least they thought they saw them hiding they saw something in the bushes. And so one of the boys like threw a rock into the bushes. And the 2 or 3 cops that were hiding in the bushes, they opened fire and shot into this house maybe 20, 30 times. It's like a little shotgun shack. Both of the boys ran away. One of them, Romeo Carr, was actually struck. And the cops drove back to the station and just sort of went on about their business. And so that was one of the first police cases that I had. And I can remember being with Ed, a white man from the South, him driving me to Monroe, Georgia, which, again, historically, it's only been maybe within the past, 15 years since there's a lynching from Monroe, Georgia, that until maybe 2017 or thereabout, the FBI was investigating it. I think 4 black people killed. Nobody's ever been arrested, right? So that's Monroe. But again, Sean sort of touched on, and we're going to talk about the community part of this and the media part of this, but Ed and I drove from Buckhead to Monroe. And as we're driving to Monroe, he sees the sheriff walking to his office. He has me pull over so that he can get out of the car and go over to the sheriff. I did not go. I sat in the car. He went over to the sheriff in Monroe and said, Sheriff, we want to know, the community wants to know who shot Romeo. Because nobody for months, they would not reveal the identity of the officers who shot Romeo Carr. So that was my first case. Went to the 11th Circuit. There's some bad decision out there from the 11th Circuit on that case. But just by way of example, in these cases, there's an infinite variety of ways that, I'm trying to check my language, but there's an infinite variety of ways that the police just mess over people. I had a case from Kroger. A black man inside a Kroger writes a check. They suspect that it's a bad check. He gets his groceries. They accept the check. He goes out to his car. By the time he gets to the car, gets in his car, they've called the police. This is Douglas County. The police come. They say he didn't stop. They shoot and kill him. a case with an APD officer who ran after a young brother, literally beat him in the head with his flashlight and killed him. So these cases come in a lot of different ways. We have a case now involving a young white man, and wow, the coverage we got for that, and I'm going to show you maybe some of the video for that. But 20 years ago, I had a case. There used to be when Buckhead was Party Central, a white couple from Tennessee were in town. They had a club out there, I think it was called The Bar, where they let people dance on the table. And his wife was dancing on the table. Some sort of incident happened inside. The off-duty police officer just brutally beat the husband. So that just some examples, and so that's kind of how I got into this work. A kill secret who's here is a criminal defense lawyer, been doing it for a long time. For me, and I say this to criminal defense lawyers all the time, the intersection between sort of mass incarceration and doing criminal defense work and police the police misconduct is just a byproduct of the mass incarceration. So anybody that has a background in criminal defense, 90% of these cases are about the Fourth Amendment. And so I think that suits you well, I think, to handle police stuff. I think Sean sort of came to this work in some different ways, but...
Yeah, I came into work just by, like I said earlier, about working here at the firm, and there was a shooting that, got to think, Mr. Cochran was known all across the world as a civil rights attorney. And when we opened the Atlanta office, obviously, we got calls about civil rights cases, and I didn't know how to do any of it. But luckily, he did. And we got a call about an 18-year-old young man named Corey Ward who was with some friends in this Buckhead area that Sam is talking about. It used to be Party City down there. And they thought that they were trying to break into cars. As these young men were leaving in the SUV, these officers pulled up. They were unmarked vehicles, unmarked uniform. So these young men didn't know who these individuals were. And as they continued to drive out of the parking lot, one of the officers, Officer Raymond Bunn, shot Corey Ward in the head. As they always do in these cases, they claim that it was self-defense and that he was in fear of his life. So I got Mr. Cochran involved. He came and did a presser. And we also put in a lot of work. Mr. Cochran taught me you got to investigate every aspect of that scene about that shooting. We even had one of Mr. Cochran's famous forensic pathologists to do a pathology and autopsy on this young man, and we used that to show where Corey Ward, the bullet entered his head and where his trajectory came. We hired a ballistics guy. We hired an accident reconstructionist. And we were able to show through the physical evidence, because what you'll see in these cases is the police are always going to say, we were in fear of our life. And this is pre-body cam days. And so what we were able to show, because of the pathologists, forensic pathologists and the forensic ballistics expert and the accident reconstruction, we was able to show that when Officer Bunn shot Corey Ward, he was actually far away from the pathway of the vehicle. As a result of that, we were able to get past summary judgment as relates to Officer Bunn. We also argued that Officer Bunn, who had a history with the City of Atlanta Police Department of doing multiple excessive force cases, we were able to show that the city of Atlanta had a pattern and practice of allowing people like Officer Bunn to continue to violate people's civil rights. And as a result, we were able to also pursue and keep a claim against the city of Atlanta under Monell. So that was my first part in that case. I realized the crazy thing about that case, it took years. And we did get resolution for the family in a nominal settlement from Raymond Bunn as well as the city. Nothing to what it should have been. But the saddest part about that case is that Raymond Bunn's murder charges were dismissed under this bogus claim of self-defense. And so we got a long way to go. That was my first 2002. And then we saw what happened with George Floyd almost 20 years later, and things are still the same. So I will say this, you need to not only be fearless, you got to want to do this and have passion, but you got to be patient and you got to be persistent and keep yourself encouraged, because it's going to be some days that you think, why are we still doing this? So that's my first case, and since then I've done a lot with Mr. Cochran, with Sam, with people in other states, so I'm here to help today.
So the first slide is just really kind of what the objectives of this program is. I mean, there are three things we really want to do. How to interview clients, what information to get when you get a call for someone from, on behalf of someone or by a person who says, they're the victim of police misconduct, how to obtain relevant information, pre-suit information, and then how to evaluate the evidence that you get. What's good about police cases, I think, compared to other sort of tort cases, is that much of the information that you need to evaluate your case, it's public information. It's available to you before you even file a lawsuit. And so that's one of the things that we're gonna talk about. But there is sort of a new era of civil rights that Sean and I have already touched on. Part of doing this work, I think, means you should be and you have to be engaged in the community. I think that means going out to investigate your cases. I think that means doing press conferences. That means being an advocate for that community as it relates to whatever sort of things may be happening with the police. For every case I've been involved in, there's always been some involvement or engagement with Black Lives Matter. 30 years ago, there was no Black Lives Matter. I think because of Black Lives Matter, that's one of that movement, that cause, I think, helps make these cases more viable. It helps get people justice. The other thing that's different is that now you got cell phones, you got body cameras, you got dash cameras in police vehicles. Didn't have that in 1999, 20, 30 years ago. That's making a huge difference. We've sort of touched on the not only increased media interest, but I think there are now, because of George Floyd and other cases, I think there are now more folks, white, black, liberal, conservative, Democrat, Republican, who appreciate that this shit is happening to people, right? And I think that is also part of what makes these cases more viable. I think people now get it. And because people now get it, I think and it varies from place to place, but I think there's more government accountability. Atlanta is not what it should be, but It's getting better, and we certainly have lawyers in the community that are pushing Atlanta to get better. But no matter where you are, I think that I believe that city council governments, county council government, state government, they are more sensitive to people's civil rights being violated, and I think are paying to resolve cases. And then I'll let Sean sort of touch on these things. And last is, there are more prosecutions now than there was, I'd say, 10 years ago, 20 years ago. It's still not what it should be, but that helps.
So I'll start where you finished, Sam. It has been amazing to see the push for progressive district attorneys all across this nation that are going to hold officers accountable in a way that all citizens should be held accountable. And my viewpoint is this: if you're going to represent your government, your community as law and order, you must be held to even higher standard of what that means. And you got to hold up the Constitution. I'm always interested in hearing conservatives or Republicans push the Constitution until it needs to be applied to people who don't have the financial means, education, social class to fight for the Constitution. Then it doesn't matter. Then it's law and order. They deserve what they got. And the reality of it is, everybody should be held to the same standard, and I think officers even more. So I'm glad to see that. That helps. But I will say this: when you have a case where the officer is prosecuted, it changes the dynamics of your civil case, and we'll talk about that probably later, because they then typically file motions to stay your case, because they don't want the officers being prosecuted criminally and also being prosecuted from a civil standpoint. But it also can help in a perspective in the media, as well as government officials, to hold them accountable. It says, hey, criminally this officer's been indicted. Criminally, there's something happened. Now, don't you guys need to take responsibility for the officer you guys allowed on the force, allowed to continue to be on the force? And the media attention that comes with that, when you have officers being prosecuted, or even if they hadn't been prosecuted yet, you can put pressure on district attorneys' offices to do something. And so all of that comes to play, but it particularly comes to play when you have video. Some of the best attention cases we've gotten, whether it be media attention, whether it be the attention of the government to try to resolve it, have been from cases where we've had body cam. We got a case with a young man named Kane Rogers. That's on video. We have a case that's still pending. Both of these cases are pending after 7-8 years. A case out of Ohio where a young man was shot in a Walmart. That was all on video. That changes the perspective and standard regarding liability, because you actually have physical evidence that you could argue a jury could consider and agree that the officer's action was beyond the standards under 1983. So all of those things come into play. But the most important thing you can ever do as a civil rights lawyer is be engaged with your community. And the reason it's important is because before you get a call from a client, you need to have the resources, the communication to get people behind you. You can never fight these fights as we saw in the civil rights era in the 1950s and 60s. You cannot do this by yourself. You just can't. And it hasn't changed. Our community is organizations like Black Lives Matter, but there's so many other organizations. But in today's time, our community is social media. It was crazy to see how many people got engaged about this boat in Montgomery. right? The community was coming everywhere, and they didn't even go to Montgomery. That's the type of mentality you got to think about in civil rights cases. You need a community like that is grassroots, on the ground, like a Black Lives Matters and other communities, other community outreach programs, like NAACP, things of that. But you also need to be able to reach the community that's on social media. So all of that has changed the game regarding civil rights cases, and you got to try to figure out how to use it to your advantage.
So in terms of police officers being prosecuted, I think that's worth some discussion, because it's something that can affect, as Sean touched on, the ability to evaluate a case or the ability to file a lawsuit. While in most of the cases, I think a prosecution of an officer who violates someone's rights, that's certainly what the family wants. That's what we want as their lawyer. What can sometimes happen, though, is, and I know we have some Ohio folks that are on the Zoom, some Ohio lawyers, Ohio paralegals. I think this is the law, and this dynamic is happening everywhere. If someone is shot and killed, like Kane Rogers, who Sean mentioned, and this has been 7 years ago, if that officer is indicted, one of the consequences of that indictment is that all of the investigation material relating to what happened may be deemed confidential by the prosecutor's office, so they may not disclose that. Every state and the federal government has some public information law. It's either FOIA in the federal context, here it's the Open Records Act, some places it's the Sunshine Law, but no matter where you are, there is some law that says this is the right that citizens have to get public records. Those public records are law enforcement investigation files. In our Kane Rogers case, we're now 7 years or so removed from that shooting and that death, because the officer has been indicted. He hasn't had a trial. So we haven't had the ability to really do any sort of discovery vis-a-vis that officer. And so that's kind of held up this case. But I consider that a good problem to have, right? I would much rather have that officer indicted and not get everything and have to wait to fully prosecute our civil case than to have the officer not indicted. But in most cases, I think most jurisdictions, someone shot and killed, there's going to be an investigation, either by their department, whether it's the city, whether it's the county, whether it's the state, there's going to be an investigation. And if that investigation exonerates or clears the officer, you'll get those files. If it raises some issues about whether the officer violated the law or it's sent to a prosecutor's office for review, you may not get those files. And that's one of the things that can make it hard to evaluate certain cases. But if that's the problem you got, that is a good problem to have, I think.
I think it's important, though, that when you're evaluating these cases in the intake process, when you're interviewing these potential clients, you stress to them your limitations regarding the ability to truly do a full evaluation, because you don't have that file. You need to let families know that it is the general rule that if particularly involving a fatality, there's going to be an investigation by internally or by the State Bureau of Investigation that could take months. They want justice now, as you can imagine. And so you have to, depending on the case, figure out a way to bring some media attention, bring some community engagement, but also cautious everyone that we're still trying to get all the information. And one of the things you can do is use the media to speed that process up and say, hey, we're demanding this department get involved. We're demanding answers. And it typically will put pressure on people, particularly now that we have body cam. Because you can't just sit on body cam in most jurisdictions. And so all of that goes into play as relates to evaluating and talking to your clients from the beginning on what some of the obstacles are going to be, because everybody wants justice immediately, and the reality of it is it doesn't happen immediately in civil rights cases. It just doesn't play out that way. So you need to know that up front in your evaluation and explain that to the client.
Yeah, and I think these are cases that require full services, and by that I mean if the prosecutor's office is evaluating charging someone, if it's a death case and they want to meet with the family of the decedent, your client, I assist my client with that. I go to those meetings with the prosecutor. If the state GBI or the BCI in Ohio, if they want to interview my client or the family member whose son was killed about what happened or his background, I lean into that. I participate in those meetings. I think that's something you have to do. In the same way as if the media is repeatedly calling for some interview or some account, I think controlling the narrative is very important in these cases, and I think there are people in the media who get it, and I think who want to help tell the story. And like Sean said, that pressure from the media, they can get answers from the sheriff's office that the sheriff's office won't give to the lawyer, or from the DA's office that they won't give to the lawyer. I mean, the media has a way of putting a spotlight on incidents where it's going to bring some stuff to the surface that's very helpful stuff.
Yeah, I agree with that. I can't tell you how many. That's why when I said the community, your community is also the media. It's a lot of reporters, investigative reporters who most news departments have a whole department that is focused on the police department. And they have sources or they have civil legal ways to get records that for some reason we as civil lawyers can't get, as well as news attorneys can't get. So you need to develop those relationships and friendships, but at the same time, you got to protect your client from the media, and because this is a fact-specific type of law, and you need to make sure you control the narrative in the story, because that it will be key, whether it be getting court of public opinion on your side early, or more importantly later, getting a real court on your side when you're arguing these issues. So make sure you keep all of that in perspective when you're looking at and evaluating a case. And I'll say this, it also means you got to look at, a lot of times the individuals that call you have been in some type of criminal activity that preceded the police misconduct or excessive force. I want my intake department, I want my lawyers to evaluate the whole perspective on that. Because everybody deserves, as criminal lawyers would tell you, everybody deserves a defense. Everybody deserves due process. But when you're a civil lawyer and you're looking at these cases, and you are looking at the person who is your potential client, did he just run away because he molested some children? That is something that you need to put in play regarding your evaluation. Because there is the reality of a violation of police misconduct, violation of one's civil rights, and there's also the reality of if you're able to prove it, what are really your damages for that particular client in that case? I'm not telling you not to take the case. I'm just telling you, you need to look at everything. So one of the things I'm saying is, what was the circumstances that led to the police misconduct? What was the victim allegedly involved in? Because that is an important part. In the Walmart case, in Corey Ward case, or Kane Rogers case, they were saying they were breaking into cars, which never panned out to be something that evidence shows to be true. But even if it was, these two young men didn't deserve to die because of a vehicle. You get my point? So those are all things that I think needs to be a part of your evaluation and analysis in the case.
So let me just give you a framework for what I'm looking for as a lawyer when I'm evaluating a civil rights intake, or when I see some craziness on TV, in terms of how I think about what I see on TV or what I see in the video, or what somebody gives me and says, this person called and they want to know if they have a case. This is sort of my thought process. I want to know whether it's a city police officer or county police officer or state police officer. That has legal implications. That's very important to know. We've sort of created an intake form. Those are things that what police department, state, county, city, and in some cases you have these, I guess, university police departments. I'm not sure what they come under, but that's one of the things I'm looking for. In Georgia, there may be certain administrative claim notice deadlines that could apply depending on whether it's a city, county, or state officer, right? But more specifically, depending on whether you think you have a claim against the city or the county or the state. So the first thing I'm looking for is, who is the officer? What police department are they from, right? So in Georgia, I think most of our sheriffs most of our county, in my experience, most of our county law enforcement are sheriffs. Although I think we do have some counties, right, Akil? I think Clayton County may have a Clayton County Police Department. But by and large, you have these county sheriffs and county deputies, right? So we see a lot of cases involving deputies and sheriffs. Cities have police departments. City of Atlanta, different cities have their own police department. And then we have state troopers, right, and other state law enforcement officers. So that's one of the things that I'm sort of trying to figure out. In terms of the law that applies to these cases, I wanted to give a little bit of background on it, but we can only we're just scratching the surface of really what all of this stuff involves. But generally speaking, you can have a civil rights case that's in state court. You can have a civil rights case that's in federal court. Now there are different things that can get you removed to federal court or vice versa. But when I'm doing that initial evaluation, I am one of the other things I'm sort of thinking about is venue. Do I want to be in South Georgia? Do I want to be in the Northern District versus the Middle District? That matters. So one of the things I want to show you, and then I think maybe we take some questions before we get into the second part of this, is a video, just a compilation of some things you've seen before and then some things you probably haven't seen it's a collage of just various different incidents of all the sort of stuff that the police misconduct. And while he's queuing that up, one of the things to keep in mind, and this is, I can speak to this for Georgia, not sure about how this plays out in Ohio, but there are certain tolling provisions for the lawyers here that apply to certain police incidents. So generally speaking, if you have a criminal prosecution or criminal investigation, there's some caveats to this, that will toll your statute of limitations, at least for a certain period of time. So we'll play this and then we'll take some questions.
First tonight on the 11 Live News at 6, our first interview with a man slammed to the ground as his arrest is caught.
We have the second clip now, released by the city of Memphis, ready to go. We want to give you another warning. This video apparently is the most graphic and the most shocking to watch. And the Sky Cop cam video, which is a pole cam, looking down at the arrest and subsequent beatdown.
County grand jury signaled that will be the extent of the criminal case. 17 other so-called police bystanders at the beating scene will not be indicted. Development noted with frustration.
The officers move in to arrest him. One of them puts his forearm around Garner's neck. More police join in, pinning him to the ground as he cries out.
What do you want?
I can breathe. Breathe in the name of it. I can breathe here.
Get up, get in the car, man.
I will.
Get up, get in the car.
I can't move.
I can wipe the whole
Darius D. Rose appearing to surrender to authorities. The canine officer still unleashed the dog on the unarmed black man. In this edited body cam video released by the Ohio State Highway Patrol, the 23-year-old cries out as officers move in.
So, I mean, part of the reason I wanted to put that video together was just to sort of give some examples of different uses of force by the police that are unreasonable or excessive. And so,
I think we should at least touch on the standards or some things. On
yeah,
the
let me, so, and this is more for the lawyers than the paralegals, I guess. But, basically, a police civil rights case, as I mentioned earlier, it's the Fourth Amendment that deals with any kind of seizure or search of someone that's unreasonable. So every incident that we saw is an example of an unreasonable seizure in violation of the Fourth Amendment, right? And so all of those are examples of excessive force, unnecessary force, force that violates the Fourth Amendment. And in the context of state law torts, that same Fourth Amendment constitutional violation in the state law context, it's an assault, it's a battery. It's also a violation of Georgia's Constitution, which mirrors the Fourth Amendment. So most of these cases, with some exception, are all sort of analyzed under the Fourth Amendment, right? And there's a test or a standard that's used in terms of whether it's objectively reasonable, right? So if you look at these various different incidents, the law says the standard is to evaluate the police officer's conduct, at least generally, is whether it's objectively reasonable.
Hey, Sam, explain what that really means to the best you can, because even judges get that confused. Subjective, reasonable. Because reasonable means objective in and of its sense. So how can you be subjectively reasonable?
Right, so there are two cases that sort of deal with the Fourth Amendment standard. Graham v. Connor and Tennessee v. Garner, right? But what the case law basically says is you look at the totality of the circumstances that were confronting that officer at that particular time, and you look at it from the perspective of whether a reasonable officer under the same or similar circumstances would have responded that way to that incident. The case also says because police have to make split-second decisions, we're not going to look back on what they, you don't look back on it with hindsight, right? You look at it in the moment of when the force was used and what circumstances that officer was facing at that particular time, right? There's also another part to analyzing this that I've sort of broken out, right? So if you go to evaluating use of force, right? This is just my way of breaking out the different factors that go into whether the force was objectively reasonable, right? The first question is, was the encounter the initial detention or stop or the initial reason the police was dealing with the person in the first place? Was there a lawful encounter in the very first instance, right? The second thing that you look at is whether there was some immediate threat to the officer, right? Is the officer responding to something that this suspect or citizen is doing that justifies the officer using force, which is why in the context of officers shooting into cars, even before you hear the full account from the news, you can predict that what they're gonna say in most cases is that the suspect in the car was using the car as a weapon, right? That they were trying to run the officer over because they have to justify what is it about what that suspect was doing that gave you any reason to believe that you or some other person was facing some sort of immediate danger of life or death or serious bodily injury, basically. And then you look at, was there active resistance or an attempt to evade arrest? There are a lot of cases where the force, like the first video you saw with the white guy, where the issue in that case is going to be, was Tyler Canaris resisting the officer's commands to put his hands behind his back? Was there active resistance or some attempt to evade arrest? But then you also look at whether or not the force that was used was reasonable and necessary. So I've seen a number of cases where, and then the law says that inevitably there's going to be some amount of force that's used when we place you under arrest. The question is whether or not that force just goes beyond what's reasonable. So we had a case involving a young man who was arrested, had submitted to the officers, was handcuffed and on the ground, and the cop was still sort of beating him. I mean, so that just goes beyond what's reasonable and necessary. And then there's a note here at the bottom is that there are many cases. Hell, George Floyd's arrest, I think there was probable cause to, the arrest itself was good. The force that was used is what was bad. So a lot of, so you'll see a lot of cases where somebody is validly arrested and they got charges pending that are legitimate. But in the course of getting arrested, they got beaten up in ways that's clearly excessive force.
And looking at this evaluating use of force, obviously this is a great checklist that you have as a lawyer, but even as intake or paralegals, because when you're doing intake on civil rights cases, you should be asking questions to get this type of information. What happened that the police encountered this client? Why did the officer feel like he needed to use force? Was he threatened? Was there any resistance? What type of force was used and what degree? Those are all questions that we want asked of the potential client before we as lawyers get involved, because those are the first things we're looking at. So this checklist is not only good for lawyers, but what I would tell lawyers to do is to put together some type of questions that in your intake department that gives you the answer of these pretty quickly. Because if you can initially get some of this, you can really determine whether you even want to be involved or not from the beginning.
Right, but you could take each of the, like the last video with the dog. The police encounter was justified. I mean, that guy, I think, had just not stopped, right? So, but he had gotten out of the truck. There was no immediate threat to the officers. In fact, and I don't know whether you can hear this, there's some state officers there, and this is from Ohio, and then I think there's some city officers there who have the dog. And the state officer is saying to the city officer with the dog, don't release the dog, don't release the dog, but he releases the dog. But clearly there's no threat to an officer. He's not, the individual, the truck driver, he's not actively resisting or attempting to evade an arrest, not at that point. I mean, the other thing you see in these cases is somebody that does like what this guy does is, now why he didn't stop initially, who knows, but he refused to stop initially, which is really irrelevant to that moment in time when this force happened. So that's force that was clearly unreasonable, clearly unnecessary. There was no real threat at all to anybody. And so, like I said, when I get an intake or when I see stuff like this on TV, I sort of go through this process. There's a video here of one of our clients who is standing outside of a restaurant in a plaza, and you see the car crash. That's a vehicle pursuit. That analysis is different in some ways than this. But if you take the George Floyd incident, the Garner incident, all of those other incidents with the taser, they all sort of go through this analysis. And so just as with this checklist, there's go to the police uses of force. You want to know, was it physical force? Was the person beaten, choked, neck restraint, whether there was, we've seen cases, you saw an example of firearms shooting into a moving vehicle, shooting into homes. That was like the Romeo car case. And then there have been some cases where you see unarmed suspects just, shot in the back. The Rodney King incident and the Memphis incident I think in Memphis, they may have had batons. They certainly did from the Rodney King incident. You saw some video of some pepper spray footage. I see a fair amount of cases involving tasers. I think there was just something in the news recently about an older man who was arrested and tased and he died. For every one of those uses of force, so if we had a City of Atlanta case, for every one of those uses of force, APD has an SOP that says, here's when you should use physical force, here's when you should use a firearm. So for the paralegals, right, Candace and Vicky and other paralegals from Mike's office who may be listening, what I like about police cases is that if Officer John Doe is the officer who's beating up Tyler Canaris, I can use the Open Records Act to send a letter to the City of Atlanta to say, I want this officer's entire training file. I want his entire disciplinary history, anytime he's ever been disciplined for anything. I want to know every time an officer, and I think this is true everywhere, every time an officer uses a taser or pepper spray or batons or firearms or physical force, they're supposed to do a use of force report. So if John Doe officer is the officer who I am looking at for the case involving Tyler Canaris, one of the first things I'm going to do or try to do through my paralegal and the open records request is send me the training file, the discipline file, any internal affairs investigations on him. I basically want to know everything there is about him, right? The other thing that I'm looking for is whether or not, and we haven't talked about this, but for police cases, there are sort of three potential parties, right? There's the officer who's committing the bad act, right? There's potentially the supervisor who may be there observing the bad act. And then there's the entity, right, who may be responsible because over the years, they have failed to provide their officers with adequate training, or they failed to discipline their officers and they let them do the same stuff to people over and over again. Those are all three very different claims. So in a police case, you don't want to, especially not in federal court, if you rush and file a lawsuit in federal court without the benefit of all that information, you're just making it tough. So Tyler Canaris, the first kid, the white kid that you saw in that first video, initially when we heard about it and saw the video, it was clear to me that the force was excessive and unreasonable. What I didn't know, but what I surmised, just because officers, in my experience, from what I've seen, those are isolated incidents. They don't do stuff like that unless they're wired that way or they've been allowed to do that. But we didn't know. But one of the first things I asked for is give me his disciplinary file. And sure enough, this deputy had been at the jail, just, roughing up people at the jail. He had a bad record. I mean, we saw in his file where the department was basically saying, look, you got an anger management problem, and if you don't do something about this, we're going to fire you, right? There's a letter in his file where I think his wife works at a veterinary clinic, and she must have told him that one of the employees said something to her. He called over to the clinic, and basically threatened to come over to the clinic and, do something to this person. So the owner of this was in his file, the owner of the veterinary clinic, they wrote to the sheriff's office and said, look, we don't want to make this a formal complaint, but please tell this guy don't ever come here anymore. He's been threatening our staff, right? So all of this I got through getting his files from the sheriff's office. So with that information, part of what I'm able, I know I'm going to sue him, right, individually, but I now think I have enough information where I can show that the sheriff knew or should have known that this guy had an anger management problem and that he was abusing people when he was a deputy at the jail. He's got incidents from when he was a patrol. He's been written up. So that's giving me a whole nother level of liability. So that's why getting that information on the front end is so important.
Now I want y'all to notice something. If you look at this list and you look at the lawyer, he's smiling and he's all happy. This is when Sam started doing civil rights cases.
That ain't now.
Now, you see him now.
No,
And my point is that this stuff is difficult because what you see in pre-suit has to be done on every case. And it's so fact specific, we are literally looking for every aspect to prove that this subjective, objective concept, the reason why I wanted Sam to explain it is really saying we got to look at it from a reasonable person perspective, but the reasonable person ain't typically reasonable.
it ain't us.
It ain't us.
It's a reasonable officer.
It's a reasonable
under-
officer who's grown up, who was trained in a system that tells him what he's doing is okay. That's why it's backwards. It's like, we gonna judge you guys on your own standard on what is reasonable actions. And not getting too detailed in the law, they actually get a bite of the apple, a free bite of the apple. You gotta have a prior violation of a civil rights to put the officer on notice that he can't do that. And so, in your jurisdiction. So, it could have happened out in California where somebody did, it's reasonable to know that if you put the dog, sick the dog on somebody, and that's a violation of someone's civil rights. But if it hadn't happened in Georgia yet, even though it's reasonable to know, you knew that from when Tony down the street put his dog on you. That ain't reasonable. But an officer has to have notice of the violation before it becomes something that he or she is held accountable for. That's why prior use of force reports. I want to reiterate that. In these reports, every station, every department has it. But it goes into great detail. What was the interaction? How did this start? What force you used? Why did you use it? What was the justification? It's all set forth on this form. And what you will find is that they lie on the form to justify. They do this before a lawyer's involved. So at least you got them stuck and specific on what they're saying is the cause. Disciplinary file, training files, that's why I always tell people, even if it's not something I can help you with because it's just not something in the cases I would consider, still make a complaint because these complaints come up later. I had a case that we used to win a case where the officer had a complaint, an internal affair complaint filed against a guy who was already in custody. He was literally handcuffed to his chair, and he was basically picking at a female officer. I think he called her bumpity bump, which I still don't know what that means. But she didn't like it, and so this other officer who attacked our client didn't like it, and he went and hit the guy while he's chained. He can't defend himself. Now, we argue that that was an assault, aggravated assault, that not only did he not get punished for it, he never got charged for it later. Because the district attorney's office should have been sent for the district attorney to consider whether charges are being brought. All those things are things that we use to show that the city of Atlanta, in that case, was allowing this pattern and practice of letting this guy be aggressive and use excessive force, and he did it while somebody was already arrested and couldn't defend himself. You still got to do your own independent investigations, which gets into this part about you got to be up for the task if you take these cases, which gives me this thing. We've done this a lot, and we have the financial means to handle these cases, but I'm always looking to partner up with somebody because these things take a lot of work. They do. And if you're out here doing this and you have a passion to do it, do not try to do this by yourself if you can't do it by yourself, okay? Because there's no way anybody does this without some help. So find some other lawyers that you can get involved with these cases with, because this is not something that you want to just tackle by yourself if you got a big governmental entity that has money to spend.
So let me touch on a few things and then take some questions. That's actually, that picture, that's Sean when the check comes in, right? So, but insurance and or indemnity, right? So this is the money part of this. For the officer from the Paulding County Sheriff's Office, that's Tyler Canaris. So in my experience, many of the sheriff's offices, maybe outside of Metro Atlanta, I don't know about Fulton or DeKalb, but my guess is many of the sheriff's offices in Georgia have law enforcement liability insurance. And in the same way that you send a letter when you get an auto case to the at-fault driver saying, provide your insurance information, same thing to the county. The county will tell you, do we have law enforcement liability insurance? There's a fair amount of insurance with Georgia police departments, I think, in Metro Atlanta. The city of Atlanta does not have law enforcement liability insurance. They are self-insured, which means if you settle a case or you get a judgment against them, it's taxpayer, city council approval. But if I had a case and it wasn't the city of Atlanta or DeKalb or someplace that I already knew did not have insurance, one relevant factor to me is, do they have insurance or are they self-insured? I think it matters because an insurance carrier, I believe, will act really like an auto insurance carrier from the standpoint of assessing, do I want to take the risk with this claim? So I think there's an increased likelihood to some extent of resolving cases when there's insurance versus city of Atlanta, you're self-insured, whatever. Let's see what the jury does. In Ohio, I've never seen this here. In Ohio, and I believe it's a state statute, I've definitely seen it in Cleveland and other places, they have indemnity agreements in their ordinances for the city of Cleveland or their police department. We will indemnify our officers, which basically means if you sue a individual police officer in Ohio, that department has an agreement legally and through the union collective bargaining agreements that they are going to to defend and pay any judgment against that officer. So that is significant. So if that were the case here, sometimes you may have a case like, again, going back to Canaris, I know there's insurance that's going to cover him. Actually, the media, all the publicity surrounding Tyler Canaris, they fired him. Maybe 3 or 4 months after the incident, just because of all the outrage. But whenever I see insurance that's going to cover an individual officer, even if I have a claim against the entity, which is a harder claim, because you got to show a pattern or custom or practice, I forego that because I know that I'm gonna, as long as they're gonna cover that officer, I'm gonna be good. The other thing that's available, City of Atlanta, if you want a sense of what's happening with these cases, what kind of money people are getting, it's all public information. If you go into the minutes for the city council meetings, you'll see the settlements they've paid or made for police cases. Do you want to do some questions now, Sean?
Yeah. Only thing I would say, put up the police use of force. Every one of these types of use of force, there's a sense of expertise and information that you need to really dive into. Tasers have their own things as relates to how they can affect somebody, when they're supposed to be used. Obviously firearms, but police dogs, pepper spray has certain aspects. The only point I'm making is if you're doing this type of work, you should already have research, database, information that you already have available to you to understand. If you get a call about this, it will really help you understand whether you have a case or not. So I would tell you to go ahead and start researching those type of use of force devices or techniques and get information about it. But I do think it's a good time to.
One last thing, sorry, and this is for Mildred and Devon, intake and screening procedures, right? So, and I created this. This is what I would, to me, this is the kind of information that I want when I'm sort of looking at a police case. That first part is pretty straightforward, although a lot of times the person that's calling is not the victim, it's a family member. But I think you still want as much information as possible about the victim. Incident information, obviously, date of incident, city and county, law enforcement agency involved, the names of the officers. I think even if you don't get this information, I think it should be a checklist of all the things you ask. Were there witnesses to the incident? Is there any evidence available about the incident? Photos, video? Is there a police report? Right? And then injuries, whether there's medical treatment or any other kind of treatment. A lot of times, I mean, all of these police abuse cases sort of are the flip side of some criminal incident or suspected criminal incident. So a lot of times folks, there's arrest information or prior criminal history that I think generally we should try to get from people when they're calling in. But let's take some questions if you all have some. Chloe?
Thank you. Thanks for inviting John Marshall students again.
You're
I
welcome.
have to leave for class, unfortunately, at 1:30, but my question is regarding the witnesses. Is it common for them to have claims based on witnessing the police misconduct and being in the zone of danger? And if so, is it dependent on the viability of the direct victim's claim?
I think under Georgia law, I don't believe there is a tort claim that you can make for being in the zone of danger. I just think generally that, and the way, I think that's sort of the way they describe it. I mean, and we've seen that in instances where, and sort of in the PI context where It could be your child or your spouse.
Not in Georgia. Other states have it, but not in Georgia.
Thank you.
If the witnesses have been either directly contacted or have some physical injury, harm, or physical, or some aspects of damages directly, then yes, but you can't rely on just me witnessing it.
Even if they have like.
Let me give you an example.
Physiological
No,
reaction.
not in Georgia.
Not in Georgia.
Not in Georgia. You gotta have a physical contact to have an emotional in Georgia.
Let me give you an example of something we're dealing with right now. Remember Rayshard Brooks? And there were some people in the Wendy's parking lot, in the Wendy's drive-thru. One of the bullets that Rolfe fired at Rayshard Brooks struck a vehicle where 3 people were inside that vehicle. One of the things we're sort of litigating now in that context is whether those individuals have a claim.
And our basis is the bullet actually contacting the vehicle. If we didn't have that, we have no arguments.
Jonathan, Akil, you guys have any? I'll go to the lawyer guest first.
One thing you didn't talk about, that I was curious about, if you have get a lot of phone calls about prison cases.
Yep.
Am I following the same rubric?
I skipped that, but, well, here, so if you go back to that, I sort of skipped it on purpose, but Bivens, there's a slide that shows Bivens, right? So, a couple things about Bivens. Bivens is whenever you have federal police officers that are involved in misconduct, FBI agents, ATF agents, or in Atlanta, they have local officers that are sometimes on a task force, a federal task force. Bivens is the Supreme Court case and the standard that applies for any lawsuits that are against federal agents, right? Bivens also has some context in terms of jails and prisons in the federal context. But if we're talking about a county jail or even a state prison, the standard for liability in the context of jails and prisons, it's the Eighth Amendment. It's deliberate indifference to, if it's medical, to serious medical. You see what I'm saying? If it's the guard that beats up the inmate, it's the Fourth Amendment. Does that make sense? So there are many cases out there, there's certainly cases out there where inmates are beaten, assaulted, or there's excessive force by a guard against an inmate. So the county, for instance, the deputies who patrol for the sheriff's office, they also work in the jail. So if this guy, McMasters, from the case with Tyler Canaris, he did things to inmates while he was assigned to the jail that are Fourth Amendment violations. So it's the exact same thing. Had he taken an inmate and body slammed him in the jail, like what he did to Tyler out on the street, exact same case. Does that answer your question?
It does.
Yeah.
Does. And I do have a little bit of...
And then let me say this about, because we haven't touched on this. The other thing that I think is more viable today than I've ever known are cases involving jails and prisons. Maybe the entire state of, I think Georgia's Department of Corrections as a whole may be under investigation by the DOJ now for suicides, deaths, But also, we have, this is not 1983 stuff, but the inmates and the folks calling about the jail cases, I think they're struggling to find lawyers like the people calling about the police cases. So I would look very closely at those. We have two now that we have intentionally filed them as medical malpractice cases, leaving out, we haven't sued any county person, because we got Fulton County and NAFCare, right? Gwinnett County and NAFCare. You probably heard about the man they found dead from just mentally ill on Rice Street, which I think they've settled that now, right?
Bed bugs, right?
I think that, what was the amount?
Was it the bed bugs?
Yeah, the bed bugs. I think they've settled that, if I'm not mistaken. But Rice Street, at the time, had a private company, NAFCare, that was doing all of the medical. Now, I don't know whether that may have been more of a inmate, a Fulton County jailer issue than medical, but for if you see cases where people are dying at the jail for not getting timely and adequate medical care, we have two very sad cases where a young man on Rice Street had some medical condition that had they taken him to the ER, no problem. Young man in Gwinnett had an ulcer. They never went in 5, 6, 7, 8 times, never took him, and it ruptured and he died. Like, these are guys in their 20s. So the jail stuff is a little bit different than 1983, but the same in the sense that we need more folks looking at those kind of cases.
And isn't there is another circumstance involving jail cases where inmates are being killed by other inmates, and whether it's gang activity,
Right.
whether it's because of the floor they're on, like in Clayton County, for example, the locks on the jail cells didn't work, so if an inmate had some animosity towards you, he comes to the jail cell at night and assaults you. One of our clients did and got stabbed 18 times. So there's that, and I think there's a recent case, I don't remember the name of it, that says that in those circumstances where the circumstances in the jail are that the jail administrators have allowed for a reign of terror in the jail, that there is a claim, and I'm assuming that that's a Eighth Amendment claim?
Yeah, I think the Eighth Amendment deliberate indifference standard is what applies from the federal constitutional perspective. However, if you have, and I just saw a case like this, if the jail at Fulton County says for any mentally ill person that's in this cell, they got a policy that says once an hour somebody is supposed to go by and look at him and make sure he's okay, and they don't do that, that can be that can be a violation, negligent performance of a ministerial duty under state law, and there's no immunity for that. That's just, and that's how I would do that. I wouldn't. It would also be deliberate indifference, but more clearly, if as a government employee you have a specific duty to do a certain thing in the Georgia context, right? To do a certain thing at a certain time, and it's in writing, it's a policy, it's an order, it's an instruction from a supervisor, and you fail to do that, that is negligent performance of a ministerial duty, and that goes in state court. You don't have to deal with federal court. You could make it deliberate indifference too, but if you did that, you're going to be removed from state court because you allege the federal constitutional violation and the state tort. Anybody else?
And knowing that, what you just explained, have you ever intentionally looked down and saw like maybe you're in the cab or Clayco or County, you wouldn't mind being in stabilized and just leave the.
Oh, all the time. Part of evaluating. I'm trying to give you an example. I think we had a case where you saw some of the video where it's from Magic City, and it's a police officer who just happens to be, he says, at Magic City. He's not working for Magic City. He just happens to be at Magic City, right? And while he's in the parking lot, one of the security comes out and says to him, somebody had snatched money from another customer inside the club, right? And so he then sort of goes into action. I think he turns on his blue lights. He goes into action. Security may have said, I think that's them in this car. And as they're driving out, he tries to get the driver to stop, right? And the driver doesn't stop. Our client, Demetric Favors, he's a passenger. The cop shoots into the car maybe 4 or 5 times, hits Demetric twice, right? And I think they fired that cop. But we took that case. So we got the case against the officer individually, which we filed with some Magic City entities in state court, right? Just state claims. The case against the city of Atlanta, we filed in federal court. So you can even separate them out. So yes, generally I think you want to stay out of federal court. And the way that you stay out of federal court is to not allege a federal claim. If you allege a federal claim, you're going to be removed to federal court. Anybody else?
Is there anybody on Zoom?
Vicky?
Is there any questions coming from Zoom?
And then let's get Vicky first. Vicky, you had a question?
Or question, comment, Sean, you may remember this, and I think it predated court award, but the client, we called him Big George, and it was the legal chokehold, and it was the CNN officer.
Yeah.
In that case, is that the same or different in police misconduct? Is it just the?
It's different because the color of law and the duties and the immunities is different. So if you got if you have a security officers, the standards are a whole lot easier because they're not a law enforcement officer that you're using the same argument. What becomes kind of tricky is when you have an off-duty officer who's providing security, but he's always under the color of his badge. And we've had that to where an officer has shot in performing an off-duty job, but when it comes down to it, they're still an officer. So you can do what Sam just said. You can sue the private entity under state claims, but then sue the police department under 1983 under the Fourth Amendment claims. All of these things really come down to this. When you're evaluating a case, you're trying to figure out what is your most viable claims with the best venue and jurisdiction. And you just figure it out. And sometimes you just go both of them, like we did with the Favors case.
Right. And then the one last thing I meant to mention that I don't think we touched on are vehicle pursuits, which I think are far too common, and they lead to a lot of catastrophe, right? You saw one where that guy, wrong place, wrong time, just walked out of the restaurant, had nothing to do with anything going on with the people on the street. He's standing on the sidewalk right as APD are chasing some kids in a stolen car on Donnelly Hollowell, maybe going about 90 or 100. And as the kids in the stolen car come around the curve, they crash into a truck on the highway. They spin out of control into the plaza where, this is also a different Mr. Favors, where Mr. Favors is standing, and you can sort of see, he sort of sees the cars coming at him. This is all happening very fast. He just moves in the wrong direction. One of those cars knocked into him. He lost both of his legs. I consider that sort of police misconduct, civil rights. That's not 1983 though. It can be, but it's not. So in Georgia and Ohio, and I think most places, most states have I think some statutes that deal with what are the circumstances when our state or local law enforcement officers can engage in a vehicle pursuit. And I think most of those statutes sort of like Georgia's and Ohio's. We have one from Ohio, even more tragic than this, 2 or 3 vehicles chasing some kids in a stolen car from like one part of Ohio to another. The kids at some point lose control of the car, crash into a car about to make a turn, hit some children on the side of the road, on the sidewalk. Some little girls holding hands walking to the library, kills one of the girls, right? That case was not in federal court. The Favors case from here was not in federal court. They could have been, but the standard is, it's not even worth talking about in terms of what the standard would be, right? Because there's Ohio law and Georgia law that gives us a standard that basically says if you engage in a vehicle pursuit and you do it recklessly or with reckless disregard for public safety, you can be held liable for that. Now, in Georgia, we got another statute that says if something happens in a city vehicle or a county vehicle that's an automobile accident or arising from the use and operation of a car, you're capped at $500,000, right? Note that wasn't so much the case in Ohio, but those are police misconduct cases that I think are very viable, especially, and maybe not exclusively, but especially if it's the innocent bystander that's calling you. The person like Mr. Favors, who's doing nothing wrong, right? Like the children like Tamia Chapman and her friends, or, and Akil and I have a situation now where we got clients that are in the car with a kid who's being, I guess, pursued by state patrol and crashes into something, and one teenager is killed, one is pretty badly injured. So I think pursuit cases far too common in terms of if you see them, I think they are certainly worth a very close look. The other kind, in terms of just categories of cases, shooting in the cars, right? Which some departments, some cities have banned that, or they've tried to say you got to have some extremely rare situation for you to be justified shooting into a car. In terms of just categories of cases that I think are significant, those are significant. The other sort of cases that are significant that might not seem like they are, are malicious prosecution cases that may involve criminal charges that may not seem like much, but somebody goes to jail, and very viable cases, malicious prosecution. And they can be state, you can make it, Georgia has a malicious prosecution tort. There's also a federal malicious prosecution, right? And those, sort of your atypical, they're not use of force cases per se.
Is there like a threshold to look at in terms of how many days? Because I got calls on that, but they're like, not jail that long, so I wasn't sure.
Well, I think it would depend on, to some extent, it would depend on the person. I mean, 3 days for me, you know what I mean? You see what I'm saying? I think, really, I mean, it depends on the person. Have you ever, is this somebody that's ever been to jail before? Is this, and if you do some jury verdict research or settle, you'll see numbers that I think would surprise you in terms of what people are getting for malicious prosecution cases. You were going to say something, Akil?
Yeah.
Okay. Anything else? Anybody got any other questions? If not, we got free lunch. Hope this was helpful. If it wasn't, we'll give you your money back. So, All right, thanks.